Good morning, friends. Welcome to Legal Matters by Sai Babu Sankara. This video is for legal ethics students. Friends, I have been telling you the Bar Council of India rules relating to the professional conduct of advocates who have completed up to rule number 44. Of course, the other 8, that is rule number up to rule number 58, they are general. We will discuss them in detail. But there are certain duties which are ethical duties to be observed by the advocates. Even though they are not directly mentioned in the BCI rules, definitely if you go through each and every rule, definitely you can find a portion of these advices or the so-called duties which I am going to tell you. Whatever it is, even though the number is not given. So just like rule number 11, you have to take up a case in which you are practicing. Like the rule number 25, you have to maintain accounts. Rule number 30, you have to give a copy. Rule number 34, you should not speak to the opponent. Like this. Even though there are no specific rules, but these things are considered definitely as a professional misconduct. That's why the word professional misconduct has not been defined. It is so much of exhaustive or inclusive definition. Right. So please remember, what are these duties? How it will come as a professional misconduct, let's discuss. So number 1, professional negligence. So please remember, professional negligence. Rule number 11, whenever you take up a case, you should attend the court on all dates of hearing, and if not, you must be able to send your proxy. You should not show negligence. Right? VP Kumaravelu case, he has gone up to the Supreme Court. Of course, luckily, it was not taken as a misconduct, but professional negligence may be taken as misconduct. The misappropriation of client's money, PD Gupta versus Ramurthy, so many things. PS Gupta, Prahlad Sharan Gupta case, so many cases were done. So you should not misappropriate the client's money. Or Bar Council of AP versus Korapad Sajrana, 2002. So where he has misoperated 14,600 or so. Luckily, because of his illness, the Supreme Court has taken a lenient view. Otherwise, he should have been removed from the roles of the advocates. Then, changing of sides. This is more important. Please remember, you may take up A's case on one occasion and immediately you should not take up B's case. So, when A's case is pending, B's case should not be taken up. So, this is what is called changing sides. This happens at the time of appeals. So, normally, you take up the case of A, then it ended in acquittal. Right? He will go to some other lawyer and go for the appeal. But since certain cases, the other side will come to you. Aya Seksha Padin Chaledu, enhanced punishment kavali. Annapudu, you should not write the appeal or you should not prefer the appeal. You should not change sides. Then, whatever you do, if you behave improperly in a court, it may be taken as a professional misconduct as well as it's called contempt of the court also. Supreme Court, it's a court of record. High Court, yes, definitely to that state, it's a court of record. They can do, even High Court 482, they can use their powers. 51 CPC, the court itself can, 151 CPC, the court itself can use its powers to do complete justice. Please remember, if you behave improperly in the court, definitely it will be taken as professional misconduct and it may be taken as a contempt of the court also. Indri versus Nandalal Badwani case, definitely. Then, furnishing false information. Please remember, while discussing section 24A of the Advocates Act, you have been told that regarding the disqualification, don't hide the required information. So here, not only that, furnishing false information. So I have myself seen in the court of, I think DJ at Ongole. I think the judge's name is Chakradhar. So what happened is, it is a claim petition under 166 of the MB Act. At that time, even though the claimant did not come, the advocate had just gone outside, put his left hand impression and filed a petition. This was observed this is discreetly, this was observed surveillance, just like surveillance observed by the judge, and he has banged him like anything. It amounts to professional misconduct. I've seen you fellow, you have gone outside just putting thumb impression, now you say that it is a fishing failure. Shall I send it to the so-called fingerprint bureau? Like that he asked. It happened in my presence. Don't furnish false information. Then giving improper advice. Of course, even though I told you a number of cases where giving not proper advice is not at all professional misconduct, but improper advice. What is improper advice? Suppose if somebody comes to you and says, "Sir, what murder chesaru? Are meer kuda inkodi cheyandra," counter అయిపోతుంది. So this is what is called improper advice. Don't do like this. Then misleading the clients in the court. So client, normally I told you that you should not be the mouthpiece of the client, but I told you that you have to hear only the client. So don't mislead the client. అతను ఏదో చెప్తుంటాడే, అది కాదులే నేను చెప్పింది అని అనకూడదు. ఎందుకంటే అఫ్కోర్స్ ఈవెన్ దో యూ నో ద లా, ప్లీజ్ రిమెంబర్ ఇట్లా కాదయా చెప్పడం కరెక్ట్, నేను మాట్లాడతాను, అంతేగాని డోంట్ మిస్లీడ్ ద క్లయింట్. కేసే జడ్జి గారు ఈ కోర్టు కాదు ఆ కోర్టుకి, ఈ బెంచ్ కాదు ఆ బెంచ్కి వెళ్దాం, ఇలా డోంట్ మిస్లీడ్ హిమ్. దెన్ నాన్ స్పీకింగ్ ట్రూత్. So you must always be able to speak truth. I do not emphasize on this because lawyers, we know. So non-speaking truth, definitely it may amount to misconduct. So having known the fact, please remember, if you do not know the fact, we can't help. Then disowning allegiance to the court. So you must, already I told you, right from rule number 1 itself, rule number 2 clearly says, have a respectful attitude toward the court. But don't disown allegiance to the court. What is disowning? రేపటి నుంచి ఈ కోర్టుకు రావండి, మేము బాయ్కాట్ చేస్తున్నాం. This is what is called disowning allegiance to the court. Then moving applications without informing that similar application was rejected by the court. This happens time and again. We will be filing bail petitions. So what is the purpose? Already judge would have told you, ఏమండి చేంజ్ ఆఫ్ సర్కమ్స్టెన్సెస్ వచ్చినాక వేద్దాము అని చెప్తాడు ఆయన. కానీ అది మనం వినకుండా అది మళ్ళీ వేసిన పిటిషన్, ఎందుకంటే క్లయింట్ యొక్క ఇంపార్టెంట్, క్లయింట్ యొక్క సాటిస్ఫాక్షన్ కూడా కావాలి, కానీ క్లయింట్కి మనం నచ్చ చెప్పుకోవాలి. అంతేగాని పిటిషన్ వేసి అతను రిజెక్ట్ చేసి అసహ్యంగా మాట్లాడితే బాగోదు. సో ప్లీజ్ రిమెంబర్, సో డూ నాట్ ఫైల్ ద applications without informing the court that already similar application has been rejected. Then suggesting to bribe the courts, bribe the judges, bribe the bench clerks also. Shambhu Yadav case, you may be knowing case. So do not suggest, do not do it. Even though the client comes you, don't encourage him. And lastly, forcing the witness not to tell the truth. The case is important for you, but truth important for the witness. Meeku chala enduku, why oath is taken? Because under the impression that the witness will speak truth. ప్రమాణం చేస్తే మనిషి నిజం చెప్తాడు అనే భావంతో చెప్పిస్తాడు. When he is able to tell the truth, why should you ask him not to tell the truth? Force him not to tell the truth. It is not correct. Of course, it is also lies with your wisdom. I can't express more things. So these are the general points of professional misconduct. Of course, I do not have any authenticity. Only just with I am saying some Google or some examples, I have written this. Not more than they are not Bar Council of India rules. So these are the things, friends. Please remember all these ethical points and behave in ethical way, become very good advocates. Right? Thank you very much.